Hello friends, in the series on the income tax cases, today we will discuss the case of RECKITT BENCHKISER Healthcare India Private Limited versus Principal Commissioner of Income Tax. This case has been reported in 102 ITAT, Tribunal Short Notes 35, and the matter has been decided by Ahmedabad ITAT D Bench. The date of the judgment is 25th January 2023. Nowadays, there are a number of the cases coming into the various judgments where there is a matter of revision by the Commissioner of Income Tax under Section 263. And we see that when the revision is done, the general allegation for doing the revision is that the assessing officer has not done proper inquiry. The question arises whether for doing revision under Section 263, which says that an order can be revised only when the order passed by the assessing officer is erroneous and prejudicial to the interest to the revenue. So the primemost condition for doing revision is erroneous. The order should be erroneous. So if the Commissioner of Income Tax does the revision on the basis that the assessing officer has not done the proper inquiry, so whether not doing the proper inquiry by the assessing officer makes the order erroneous, this is the moot question. In Section 263 or in any other section under the Income Tax Act, it is not prescribed that to which extent the assessing officer has to make the inquiry. It is totally the prerogative of the assessing officer to decide in a particular case, and depending upon the facts and circumstances of the case, that what inquiry has to be done. The order is erroneous only in a case where the assessing officer fails to apply the provisions of the law in a particular case properly. When the law has not been applied properly by the assessing officer, that makes the order erroneous, but not the proper inquiry or inadequate inquiry made by the assessing officer, because it is the AO who has to decide that what inquiry is adequate or proper in a particular case. In this case, the assessing officer during the assessment proceedings issued questionnaire regarding the TDS, and the assessee replied to that notice in a very exhaustive manner by giving all the Excel sheets in which the assessee told that on these items the TDS has been deducted under the various heads in which the TDS has been deducted, and where the TDS was not deducted, the assessee showed why the TDS has not been deducted on those cases where the threshold limit was not crossed, and when the payments made by the assessee were below the threshold limits, only on those cases the TDS was not deducted, and where the TDS was deducted at lower rates, then the assessee has produced the certificates produced by the various deductees. So the assessee has complied properly with the questionnaire raised by the assessing officer. But the Commissioner of Income Tax initiated revision proceedings under Section 263 on the allegation that the assessing officer has not made proper and adequate inquiry. So the assessee moved to the ITAT, and ITAT held that it is not the prerogative of the Commissioner of Income Tax to tell the assessing officer that what inquiry you should have done. If the assessing officer has done the inquiry according to his wisdom, then on that basis the order passed by the assessing officer cannot be termed as erroneous. Friends, we have seen that a number of the cases are coming in which the revision has been done under Section 263 only on the basis that the AO has not done proper inquiry. So if the Commissioner of Income Tax feels that the assessing officer has not done proper inquiry, so that does not make the order erroneous. For making the order erroneous, the Commissioner of Income Tax has to prove that the assessing officer has misapplied the provisions of the Income Tax Act in making the assessment order. At the end of this video, Once again, I am repeating the name of the case. The name of the case is RECKITT BENCHKISER Healthcare India Private Limited versus Principal Commissioner of Income Tax, and this case has been reported in 102 ITR Tribunal short notes page number 35, and the matter has been decided by the Ahmedabad ITAT D bench, and the date of the judgment is 25th January 2023. Thank you, friends.